Hi everybody, welcome to a unique episode of Enthusiasts. I was going to make it just a short blurb in an episode of Stay Tuned, but the more I looked into this story, the more bizarre it seemed, and the more worthy it seemed of its own standalone episode. There was much more to the story than I first thought. So let's dig in. All you need to know about a bizarre, twisty story going back years related to Pras Michel of the Fugees and his legal issues. Let's go back to the original indictment, the original charges as described in the official documents. So, April 2017-ish through January 2018, George Higginbotham and a group of other people who were given names like co-conspirator A, co-conspirator B, etc. in the original indictment. So I'll just say CA, CB, referring to co-conspirator A, B. Higginbotham and them basically were accused of misrepresenting the true sources of tens of millions of dollars from foreign accounts they were moving into U.S. financial institutions, finding sneaky ways to conceal the truth about where money was coming from. The indictment laid out the allegations like this. CA asked Higginbotham if he could help him find someone influential who could handle CB's problem. CB did not end up choosing the recommended lawyer, instead pursuing help elsewhere from a, quote, non-lawyer business owner and financer with political connections at high levels of the United States government to lobby government officials to resolve the 1MDB matters, unquote, 1MDB referring to a wealth fund. Person 1, to avoid a direct paper trail linking him to CB's behavior, had Higginbotham basically find a way to make CB anonymous and transfer money through pass-through entities instead. Person 1 agreed to the deal and was trying to influence a federal appointment that could affect civil forfeiture cases like his. So basically, this is backroom lobbying for affecting a federal appointment, thinking maybe you could get someone appointed who would be more favorable to dropping charges against you, to ruling in your favor, etc. At the same time, they were doing this illegal lobbying to try to get someone extradited who was in the U.S. on just a temporary visa. They were trying to influence government decisions off the books while being shady about money. That is the nutshell version. CA requested that Higginbotham meet with Country Q's ambassador to the U.S. Country Q, as it's called anonymously in this indictment, I think it's China, because the person they wanted to extradite is from China. So anyway, meet with Country Q's ambassador to the U.S., presumably the Chinese ambassador. From May to September 2017, tens of millions were transferred into a U.S. account that CA controlled, so it looked like. CA was the face of it. CB was the real controller behind the money. CA was his cover. Higginbotham's role was facilitating fake investment agreements, consulting contracts, loan documents, legit-looking documents, basically create receipts, so if any bank gets suspicious, like, where's all this money coming from, he could pull out those contracts and be like, these are the services we're getting paid for. They're legit jobs, not bribes. There was much more scrutiny on banking activity, especially cross-nationally, after 9/11. So then, they had a meeting like, what do we do? And CB thought, well, to really avoid getting caught still, it would be better if we started sending smaller amounts of money more often, rather than big chunks at a time. Looks less suspicious. Then there was some tension within the team, because apparently CA and Higginbotham had a plan that they didn't want CB to carry out. CB told Higginbotham to sign documents giving him control over Company R and its assets, knowing that CB still had the power over that account, but another person would be signing on to present a cover, a front. Person 1 was displeased with this plan and the fact, quote, the trip to Country Q had not resulted in additional funds being sent to the United States, unquote. Yeah, all this lobbying at the end of the day actually didn't work. They didn't influence that appointment. They presumably did not influence the extradition decision. All this scheming, not to say it would have ever been worth it, but it was for nothing, especially because they flopped at it. So they had a new plan, trying to get back on the same page in the fall of 2017. More funds were going to go to Person 1 and Associates through a Higginbotham attorney account. Later that month, casually, around $41 million was deposited from foreign company R into this Higginbottom account at CB's direction. CB is still calling the shots behind the scenes. CA then ordered Higginbottom to disperse some of those millions for funding for what they were calling entertainment projects. This was basically CA's paycheck for helping as this intermediary to get that money into U.S. accounts. Higginbottom lied when he told a financial institution the millions were transferred by foreign company L, not by him or CB or those affiliated people. So foreign company R, they owned, and that was the true source of the donation, the money they funneled into the U.S. But he said it was company L. You can't just lie to a bank. That's also a charge against him. That is a criminal matter. But he still said those were for entertainment matters, plus legal aid to, quote, resolve a highly complex civil litigation matter. He also included, with this letter, he included a copy of one of his fake consulting contracts. And the excuse did not fly, so that institution closed the account. They did not permit new deposits in it. They dispersed what was left, which was a paltry $37 million that went to institution Y. When it got to Y, CA claimed again that is entertainment project funding from a foreign investor. Overall, CA and Higginbottom both lied to institutions to conceal the true source of funding, and they did not want to reveal the real reason people were getting paid off, which was trying to influence political decisions, off the record. In May 2019, a 4-count indictment was issued against Pras Michel and Joe Low, Jhollow. They were accused of being co-conspirators in this report, illegal lobbying to give money to Obama's re-election campaign, and not telling the FEC, Federal Election Commission. So now we know the person the original indictment said they were trying to coerce was former Republican National Party Deputy Finance Chair Elliot Brody. They wanted him to do unregulated, back-channel Trump administration lobbying. So one illegal lobbying attempt had to do with trying to get the Trump administration to do what they said when it comes to the extradition. The other was the accusation of illegally giving money to Obama's re-election. A third charge was because of conspiracy to violate FARA, the Foreign Agent Registration Act, which is interesting that later than the legal argument put forth was that Pras didn't have to register as a foreign agent to influence China because he was not working on behalf of another country. So the law doesn't apply that requires that registration because that registration is just when you're working on behalf of another country. And this was on behalf of the U.S., which is an interesting spin. So this investigation had many tentacles, but the 4 official charges were conspiracy to violate FARA, F-A-R-A, with Brady's help, illegal lobbying in the hopes of getting that extradition, conspiring to conceal the money they got during the FARA violations, and conspiracy to transfer funds into the U.S. while lying to banks. Later, Pras's less-than-stellar lawyer, who made this argument deemed so bad it was grounds for a new trial, or part of the grounds for a new trial, was, hey, this lobbying wasn't about foreign influence or anything that grand. All this lobbying was just going towards the goal of getting Joe Low the photo with Obama he wanted. Yeah, this was all for a photo for a starstruck Joe Low. He also made the argument that is not how the law works, that his client couldn't be guilty of conspiracy if he didn't succeed at the conspiracy, which is not how that works. The word conspiracy, legally and otherwise, refers to the wrongdoing being the hatching of a plan, regardless of whether it works. It's like you can't be arrested for murder if it was attempted murder, not how that works. The lawyer also ended up mixing up his arguments because there was the conduit scheme and the lobbying scheme that he kept conflating. So in one case, he was supposed to argue against the prosecution saying this was politically motivated. The other was more about helping out a buddy. The extradition and stuff, accusations of funneling money to a campaign, obviously political motive, but not necessarily so much political when they tried to get a different appointment to that position, hoping that it would help bail their friend out. So he conflated and argued at the wrong time that they had the politics of this mixed up. Back to that comment about getting the photo, quote, "You could call it whatever it is you want. This is a man who had the money, the wherewithal to spend anything he wanted to do or spend. You heard about this man spending $1 million a day to rent a yacht for 40 days to party in Europe. This $20 million to him was nothing. To Pras, $20 million transitioning into a new life and new career was incredible for him. He wanted to make that money. He did get that money. And he did try his very, very best to get Joe Low that photo." Unquote. It sounds like what he was trying to say was that Pras took a bribe because he needed the money and it was life-changing, and the reason millions, literally millions, were offered for this photo was because that was chump change to the guy who offered it. So he simultaneously tried to argue that dollar amount makes sense why he would accept that for this photo bribe, and makes sense why someone shelled out that much, because to him, it wasn't that much. He's arguing at the same time it was an understandable amount and it was a massive amount. There could be, I guess, a really clever way you could make both arguments at once. He was not ready to be that person. So the 4-count indictment came first, but then came a 12-count superseding indictment issued in June 2021. Which added on counts of witness tampering related to straw donors, basically people who play the face of a financial transaction to hide the true source of the money, so it can stay not disclosed. The trial could have been in fall 2022, but Mr. Kenner, Pras's lawyer who made the photo argument, said he suffered a bad fall and needed a trial date extension. Pras says he never actually disclosed specifics about how he got injured, but he was wearing a cast, so do with that what you will. March 30th, 2023, the trial finally got going. On April 26th, 2023, Pras Michel was convicted on 10 charges. 2 ended up getting dropped, so that means he was guilty on all charges against him. Charges of conspiracy involving 3 lobbying schemes and 2 presidential elections. This had to do with a 2012 and a 2017 incident that were both tried during this trial. So that was April. May 10th, 2023, a press release went out for the AI company iLevel.ai. They touted in the press release, quote, "the first use of generative AI in a federal trial," unquote. Later, Michel's publicist said, "Yeah, Kenner told us the AI usage." So people found out he used AI in his arguments in court because he kind of bragged about it and put it in a press release. Plus, an iLevel employee bragged on LinkedIn, quote, "AI startup I've been working on is now the first use of AI in a federal criminal trial. Defense lawyers used our platform to rapidly research and help draft closing arguments. It's never been done before, and we're just getting started," unquote. So how do we know Kenner really officially is associated with iLevel AI? Well, the company's statement denied he has a financial investment in the AI company he used, and they asserted that they offer, quote, "a powerful tool for human lawyers to make human decisions, but do so faster and with far greater information at their fingertips. iLevel is able to ingest and understand complex legal transcripts based solely on the facts of the case as presented in court," unquote. The primary address for iLevel AI is the same address as Kenner's law firm. So from a press release and LinkedIn post touting this company as having to do with this specific trial, yes, the LinkedIn post did cite Pras Michel in particular, and the primary address being shared, I think it's pretty clear. The official request for a retrial that Pras's new legal team filed really slams David Kenner for a ton of reasons that I will summarize for you. This was way beyond just AI usage that they said made his defense ridiculous. So claim number 1/argument number 1 for a retrial, David Kenner outsourced his arguments. He left them up to AI, causing an incomprehensible jumble of arguments, with major conflations and inaccuracies. The most interesting is his misattribution of a lyric. He said, "Ghetto Superstar, That Is What You Are," was a song by the Fugees when it was just a Michel song. He also managed to quote, during his defense, "Every single day, every time I pray, I will be missing you," which is a Puff Daddy lyric that he attributed to the Fugees. It is so wild, as I was reading this official legal document, to see the sentence, quote, Kenner's reliance on an experimental AI program may also explain why the closing argument misattributed a Puff Daddy song to Michel's group, unquote. Pras' statement on his own behalf for a new trial also brought this up, where he said, hey, if my lawyer had even bothered to show me his opening and closing arguments, I would have pointed out he misattributed a Puff Daddy lyric. Argument number 2. Kenner was out of his element from the start. He was taking on a case dealing with FARA, a topic he knew little or pretty much nothing about, nor did he have legal experience. Kenner does have 5 decades of lawyer experience, but not in white-collar crime. Mostly he's taken cases of burglary, robbery, assault, drug offenses, not at all this kind of situation. He has gotten some big wins, though, like Snoop Dogg's murder trial that way too few people seem to remember happened, and he also has defended Tory Lanez in court. Argument 3, Kenner might have felt pressured to turn to AI for assistance, not just because he was out of his element, but because he had a financial stake in eye-level AI. He has a financial interest in CaseFile Connect, a company that sells software marketed as saving lawyers tons of time with their AI. And CaseFile Connect is, quote, technology partners, unquote, with iLevel. Kenner is longtime friends, too, with the co-founder of CaseFile Connect. The alleged conflict of interest here was not something Pras was ever told. He found out when the public did. Argument 4, Kenner was so ill-prepared and just disorganized. Pras says they never went through questions together. He was never prepared for his testimony, so it was quite last minute when they decided, yes, he'll take the stand, and he did not have time to prepare at all, so how could he defend himself well up there? He also sounds like he was quite conceited. So like when someone would point out, hey, what about this? Or I think this you're misinterpreting or whatever. Or maybe we should go over this. He would say something like, I have decades of experience. You don't know what you're talking about. I know what I'm doing. That kind of thing. Plus the prosecution's case is weak. We've got this. Don't worry about it. Don't underestimate me. The contracted attorneys on Kenner's team was not exactly the A-team. They were quite underqualified and out of their familiar realm of legal cases too, but these clerks essentially were tasked with drafting the opening statement, drafting motions, preparing direct examination of Michel on the stand, preparing cross-examination, essentially everything, despite not knowing what they're doing, and one attorney even had on his website confirmation that his sole trial experience was in medical malpractice. Here's a direct quote from the motion for a new trial. Defense counsel have also asked Mr. Kenner for basic discovery, such as the witness interview memos, but Mr. Kenner indicated that he does not have these and referred new counsel to the e-discovery vendor. The e-discovery vendor declined to make the discovery available because its bills for work performed at Mr. Kenner's request remain unpaid, unquote. They also argue Kenner was having a second conflict of interest because during this, he leaked grand jury material to the media. So prosecutors filed charges against him to hold him in contempt of court, which could affect his future ability to practice law and keep his license active. That surely affected Kenner's focus and performance since he was focused on fighting a contempt charge against himself while trying to represent and prepare to help his client. Number 6, the jury was misled due to an unjust use of an oversight witness. They viewed too much lay opinion testimony, as they put it, during this trial. There is a DC Circuit ban on that kind of testimony, and the over-reliance on layperson witness testimonies, a kind they cite as being a part of this case at least 25 times. And lastly, they argue the judge also tainted the jury's decision-making by disclosing certain info in their presence that should have been discussed with the lawyers, the prosecutors, when the jury was not in the room. So then the jury heard what the judge said about the judges before who had already deemed Michel guilty of conspiracy. Worse yet, the judge didn't accidentally say that these previous judges had already formed opinions about Pras. This judge actually encouraged them to take that into account when they went back to deliberate. Basically, the judge was telling them to factor in to their debate about guilt or innocence statements made from a separate, irrelevant time. That's not allowed. Juries have to focus on what was presented in that very specific trial. Quote, the court erred by making the jury aware, over the defense's objection, that the grand jury judge issued a crime fraud ruling finding that Michel had conspired with Higginbottom and others to commit the charged crimes, unquote. This new lawyer for Pras also said 2 judges and a lead case agent all had their he's guilty opinion heard by the jury early, reducing the jury to a, quote, rubber stamp, unquote. And this motion for a new trial cites that the judge did not follow the comments with a reminder that should have been there. A reminder about probable cause. Because fine, if you want to accept these comments and factor them into your decision making, that might lead a jury to say probable cause. But in this case, it's about guilt beyond a reasonable doubt, not probable cause, more likely than not it happened. Beyond a reasonable doubt, much stricter standard. That didn't rise to the level of guilt beyond a reasonable doubt, what those judges said. So to recap, the request for a new trial says that Kenner outsourced his arguments because he was out of his element, disorganized, incompetent, conceited, plus he had a financial and marketing incentive to turn to AI because of his buddy's company and his own part in the company, technology partner company. The overlay witness and hearsay were used too often in court, and this lawyer, they called incompetent, did not challenge it enough. The judge tainted the jury process by disclosing info and having them consider info that should not have been part of the decision-making process. And Kenner had another conflict of interest issue because he was also dealing with contempt charges due to leaking grand jury material. So, in closing, they said, quote, the AI program failed Kenner, and Kenner failed Michel. The closing argument was deficient, unhelpful, and a missed opportunity that prejudiced the defense, unquote. Also, quote, Michel never had a chance. Michel's counsel was deficient throughout, likely more focused on promoting his AI program and saving himself from the contempt proceedings than zealously defending Michel. The net effect was an unreliable verdict, unquote. One more. The AI resulted in, quote, frivolous arguments, conflated the schemes, and failed to highlight key weaknesses in the government's case, unquote. Pras' statement himself included some interesting notes. One is that he now says it was a mistake. He had an arrangement with Mr. Kenner to pay him with a flat fee. He says in hindsight that was not a good idea because that means if he took on a second case and just severed these cases, the conduit and the lobbying one, he might have been more efficient in his arguments when he got to cleanly sever the cases and not had this garbled mess conflating too much. But he didn't argue to sever the cases into separate trials, the counts into separate court cases, because that meant he would be doing more trials with no extra pay. Same pay, more work. That was not a good incentive structure. He also said, quote, Mr. Kenner rarely took notes and frequently confused the multiple schemes charged. Mr. Kenner never articulated an overall defense strategy or theory of the case, nor did we spend time together reviewing key documents or witness interviews. Mr. Kenner did not share with me a copy of his opening statement or closing arguments, unquote. And he brought up how this protective order against loose-lipped Kenner really hung over his head, making him fret about every decision he made on their case. His then downright paranoia about the government on his tail did not help his calm, cool, collected self make a legal case while that was hanging over him. Jasmine Zaki talked about her role in this case and preparing for it in her letter submitted in support of a new trial. Quote, I was taken aback when Mr. Kenner began asking me the most basic questions about FARA, such as who it covered and what types of activities it covered, unquote. And she said she first thought they were testing her, like checking what she knows. But she soon realized no, they're genuinely asking these questions because they don't know. Then they asked if she would be their star expert FARA witness on the stand, which she declined because she's like, I know about FARA, but I'm no expert, no way. And I can get you an expert, but he didn't want who else she had in mind. She said she spent less than an hour helping with the trial team prep, but apparently she gave such good definitions like what FARA is that they were so blown away they wanted her to be their expert witness. Lastly, vouching for a new trial was attorney Joel DeNaro, who has experience in both civil and criminal litigation and has been practicing law since 1999. And he knows well Mr. Israeli. I'll just call him Mr. I. He's the guy who runs Case File Connect, who's longtime buddies with Kenner. Mr. DeNaro claims Mr. I is not a practicing attorney, period. His job is running the e-discovery company, BIA, Business Intelligence Associates, which was acquired last year. He said a few weeks before the trial, Mr. I called him and asked if he could come down to LA to help with trial prep, which he did and got a retainer for. He was asked if he had a FARA expert they could use to testify, and he did have one to recommend. They did not go with the expert he recommended. Here's some bonkers official quotes. Mr. DeNaro indicated that it was clear to him that the trial team was unprepared. For one thing, Mr. Kenner was not familiar with some of the key documents that were referenced in the superseding indictment. For another, Mr. Kenner did not seem to be familiar with FARA or the money laundering statute and how it applied to the alleged facts. Mr. DeNaro tried to explain aspects of the money laundering statute, but did not believe Mr. Kenner understood what he was trying to explain or the possible defenses he suggested. From what Mr. DeNaro observed, there were no hard copies of discovery materials in the office, and he did not see binders of 302's government exhibits or grand jury testimony, unquote. 302s refer to witness interviews. So apparently, in the trial prep, all hands on deck, argument preparation, big room where it happens, where all the planning happens, he saw no hard copies of material, no exhibits, no testimony, and no witness interview transcripts. So what now? The sentencing date, still TBA. Will he get a new trial? I would argue he should. That's my opinion. Higginbottom pled guilty to his part in this in 2018, and still apparently, as of recording time, hasn't got a sentencing date. Yeah, the justice system runs ridiculously slow. Brady, the RNC guy, pled guilty to his role in the back channel negotiations. He pled guilty in fall of 2020, then got a presidential pardon from Trump in January 2021. One person involved, Lum Davis, pled guilty in the summer of 2020 and was sentenced to 2 years behind bars. Regarding Joe Lowe's financial frauds, Goldman Sachs pled guilty and has paid billions in fines because of it. Joe Lowe, as of recording time, is still a fugitive. He's on the lam, as he's been for years. There are many rumors about where he's staying and who he's staying with. Al Jazeera said in 2020 he was taking up residence in Macau with a Chinese Communist Party senior member, which China denied, but he was spotted by a witness via cell phone camera in a picture from Disneyland Shanghai in 2019 on Christmas Eve. Yeah, that is a movie. Someone's on the lam, but gets spotted on Christmas Eve at Disneyland. What a photobomb. So anyway, he may or may not be in China. Apparently there is an Interpol red notice out for him, and the Malaysian government issued an update this past May saying that they're working with many other governments right now to track him down and extradite him. Joe Lowe actually has had quite a life. We could probably do a whole other episode about him. He's been living large, but then the Malaysian Prime Minister found out what was going on back in 2014. Basically, most of his money from this 1MDB fund, which I keep accidentally wanting to call the IMDb fund, which is so not what's happening. But anyway, so this fund mostly consisted of illegally obtained wealth, embezzled money he put in shell companies. And so the Malaysian government found out what he was doing, that a lot of his wealth was not legit. So in 2016, a U.S. attorney tried to recover $1 billion in assets from him. So for years now, he's been on the run. And as this trial played out, and they're accused of working with him, they call him a fugitive. Like, he's been a fugitive on the lam as he was involved in this story. Lots of other interesting characters testified or at least were set to throughout the Pras Michel trial, most notably probably Leonardo DiCaprio. He was involved because his movie, The Wolf of Wall Street, was in part funded by Joe Lowe affiliated business. And he said in the stand, Lowe offered up maybe 20 to 30 million, which he found a legit deal. Both him and his studio greenlit the offer. The reported total budget to film that movie was estimated at around 100 million. So if Joe Lowe ponied up 20 to 30 million, that's not the bulk of it, but that is still a significant percent of it. So what have we learned today? One is that karma catches up with you if you don't represent your client well because you want to promote yourself or just save your own skin or whatever. Maybe that's not the job for you. But also, karma will get you. The legal system takes forever. That's another lesson here. If you think you're getting away with something, maybe you're not. They're just finding evidence for even more counts against you. Years down the road, karma will come for you again. I guess we also learned today that you shouldn't brag about crimes on social media. That's probably a good rule. I would also say don't claim you did back channel work just to get a photo with someone. Doesn't sound like a sound legal argument. We were also reminded that you should not misquote Puff Daddy and the Fugees. In all seriousness, though, I think this is an important story because it really could be a harbinger of nightmares to come in our AI dystopia. This could be a good example. As of recording time, there's no announcement about a retrial, but at the very least, a hearing should be had about what has happened. Because this should be a we're nipping this in the bud moment where the legal world draws a hard line against AI usage. It's just too faulty, too unreliable. I know humans are unreliable, but AI in the picture does not help. And it brings up so many ethical questions about true representation as zealously as possible for your client. And you should have to live with a sense of your conscience, a sense of your full responsibility, full moral obligation to your client to have personally invested all you could in their success. Share the victory or share the regret, but to try to pass off any sense of victory or regret for your performance as a lawyer, passing that feeling on to and blaming AI, not a good idea. Just something I'm thinking about. So much more I could say about this case because it's endlessly fascinating. This was just a snapshot version of it. Thank you all for tuning in. I will talk to you all again very soon. Bye, everybody.